Hello, I'm attorney Francesco Ficci Martinez with Ficci Martinez Law Firm P.L.L.C. I am an immigration attorney with offices in Jacksonville, North Carolina, Fayetteville, North Carolina, and Greenville, North Carolina. Today's topic is K-1 Visa Holder married after 90 days. What to do? If the fiancé entered the United States on a K-1 Fiance Visa, but the couple did not marry within the 90 days after entry, the foreign fiancé is considered to have overstayed her fiancé visa. There are two very important distinctions on marriage after that 90-day point. Marriage to the intended fiancé, the I-129F Petitioner, or marriage to another person. That first one, marriage to the intended fiancé, the one that petitioned, the one that started the I-129F, the fiancé visa process. An overstay of the K-1 Fiance Visa may still apply for adjustment of status and receive a green card through the U.S. citizen spouse. However, the I-129F petition would be invalidated. It was only valid if a marriage occurred within 90 days. After the 90-day point, a new petition would be needed. When someone, a non-U.S. citizen, marries a U.S. citizen, and they are in the United States and they entered legally and they meet a few other qualifications and they aren't rejected or restricted by other means, the general petition is an I-130 petition for an alien relative. A spouse of a U.S. citizen is deemed an alien relative, an immediate relative, in fact. However, USCIS may require a reason for failing to marry within the 90 days. The couple at that point would have given many statements to USCIS, to the consulate, that they intend to marry within 90 days, and in all honesty, 90 days is plenty of time to marry someone. Some people, when they come in on the fiancé visa, would marry within the first week. Others might want to give the relationship a test drive and wait a month, wait 2 months. Getting closer to that 90-day point is scary. So if you have a reason for not marrying within the 90 days, please let it be a good reason. Hospitalization, someone was in a coma, someone was immediately deployed if they're active duty, or their job took them outside of the country. Immediately there was no warning, and there was no way for that person to come back. It was against their will. There was no physical way for both couples, both fiancés, to be in the United States to marry. Okay, so if you're able to explain your reason, and it sounds good, filing a new I-130 and going through USCIS to adjust status from K-1 visa holder, K-1 visa overstay to that of a green card is possible. However, if USCIS finds that fraud was present, visa fraud, immigration fraud, the newly married couple could face complications and be required by USCIS to pay a waiver for the violations. The waiver currently costs $930. However, there is a possibility that if the waiver is denied because USCIS does not agree with the reason for committing the waiver, the reason for committing the violations, and it's the kind of violations that they can't waive, or the waiver application was completed insufficiently. A denial of that waiver would lead to a denial of the green card application, which could lead to deportation. Now, the second scenario. If a fiancé marries somebody other than the I-129F petitioner, they just married some other U.S. citizen after they arrived on the fiancé visa, you should speak with an immigration attorney. Overstaying and marrying a non-petitioner will require the foreign national to leave the U.S. to attend an immigration interview abroad. Once you exit the United States, generally, an admissibility bar is triggered. The bar may be for 3 years, may be for 10 years. Additionally, if a bar is triggered and an exit of the United States occurs, the waiver of that bar could take over a year to complete, meaning a trip outside of the country to attend an interview was expected possibly to only be a 2 to 3 week trip, could be a 1, 2, 3, 4, however many year trip outside of the country, keeping a young couple apart. It is highly recommended that you speak with a professional, speak with a local immigration attorney that would be able to explain the entire process and also would be able to evaluate your situation more closely. Overstaying any visa may lead to deportation. It is wise to honor the CBP's I-94 permitted time in the U.S. CBP places a date on the I-94 stating when someone is going to overstay their visa, when they are supposed to leave. If you overstay your visa, again, the admissibility bars may apply, and that would complicate later filings. I hope this video has been helpful, that it answers your question on what to do after the 90-day point. There are two distinctions. You should definitely consider that when doing self-research on this topic. If you are in this situation, it is highly recommended, again, to speak with a local immigration attorney to explain the many forms that are needed, what processes, what agencies need to be filed with, and also the processing times that would correlate with the forms and steps that have to occur in order to apply for a green card after the 90-day point. Thank you so much for your time. Have a good day.